waters of the lakes up by
Yeah, we
Sealy.
were up at Holland most of the weekend getting eaten by mosquitoes. But
Perfect.
we also ate some s'mores, so it balanced out the terror there.
There you go. You keep the mosquitoes out of the s'mores.
Yeah,
I hope so.
they were all basically biting my youngest son, so they didn't bother me too much.
So he's the mosquito magnet.
Oh, my goodness. He looks like he has chicken pox.
Every family needs one.
Yeah.
All right. Anyway, but Rob Natelson joining us this morning from the Independence Institute in Denver. Good morning, Rob.
Good morning from mosquito-free Colorado.
Speaking of mosquitoes, we have a lawyer on the line.
Oh boy! Hey, listen, I couldn't even believe it when I saw it. My wife and I, of course, we didn't have fireworks in Missoula because the Southgate Mall canceled their fireworks display. So my wife and I were watching the PBS thing from Washington, live from Washington with the bands and playing the Star Spangled Banner and the Stars and Stripes Forever and all the guest singers. And then they had the big fireworks display. But I guess in Washington, you can lie about anything because what they did on the broadcast, because it had been raining and the skies were cloudy, they decided not to do the fireworks. So they just put in fireworks from previous years, interspersed with the musical numbers, and they didn't tell anybody about it. It was like,
well,
come on.
Peter, if you've seen one fireworks display, you've seen them all.
I get.
And after all, Peter, what difference does it make? What difference does it make?
Famous last words. I love that. All right.
That's great.
And later on, PBS apologized. Oh gosh, I guess we should have let you know they were from, other years. Sorry. Anyway,
Anyhow. Well,
so aside from that,
we have Rob Natelson on the phone, and we're totally abusing our time with him by talking about fireworks.
Shame on me.
And mosquitoes. But just so you know, to catch you up, Rob Natelson is an author, constitutional law professor. He used to work here at the University of Montana. He now works at the Independence Institute, which, by the way, if you want to read some of his articles, there's a link in the Talkback Weekly lineup for today. You can go to the Independence Institute and see some of his current work. He's also written a book called The Original Constitution, What It Actually Said and Meant, which you should check out if you want to get an idea of that.
I have a signed copy.
But I noticed you've got a piece in the work. It is unpublished, so we'll probably get a little bit of an early taste on this one. But you're discussing rights as they're interpreted by the modern Supreme Court. Is that kind of the gist of it?
Yeah. In some ways, the modern Supreme Court is a pretty responsible institution. But in the area of individual rights, they seem to have gone completely off the rails. And this particular article discusses 3 cases that come from the term that just ended, illustrating what I mean by going completely off the rails.
Now, the term that just ended, I also understand, is one of the first terms where a piece of work of yours wasn't cited for the last 4 or 5 years.
Yeah, that's right. Well, let me correct that. This is the first time in 4 years that I haven't been cited in at least one opinion by a justice. However, if you go and you look at the Supreme Court records, you'll see that the briefs offered by parties are filled with my citations or citations to some of my work. I think it was just that the relevant cases didn't get up to the court, and they weren't decided this term.
So do you think it's your fault that they weren't decided the way you wanted? Is that?
Well, yeah. I mean, they should have. They should have immediately taken any case in which I was cited and decided it the way I wanted. Well, it was a little bit embarrassing last year when Chief Justice Roberts issued a dissenting opinion in which he cited something that I had written, and of course I was on air. It was my first time actually to be cited by the Chief Justice, but he cited my article in a dissent where I actually agreed with the majority. I mean, he cited the article correctly and for the point of law he was making, but in his larger opinion, I don't think he was correct. I think the majority was correct. So that was kind of, I don't know, sort of like kissing your sister sort of feeling.
Well, I think perhaps it might be a good idea for us to not impose, but encourage the Supreme Court to have a Rob Natelson, red phone, the hotline, from their offices to your office, so that hey, when they're a little confused, hey, what would the framers have said about this?
They could set it right next to the Rob Natelson dartboard. That they could get that on loan from the university.
There are plenty of Rob Natelson dartboards.
Oh, boy.
There are probably hundreds of them left in various attics in Montana. But no, I don't really want a hotline from the Supreme Court. I'm not sure I want to spend that amount of time.
I hear you. Well, let's talk about some of these decisions that you've said, especially the First Amendment protects it. You said free exercise of religion, and this is one instance in which you said, hey, this is something terribly wrong here. Yeah,
it really is. The theme of the article that, as I mentioned, has not yet been published, was just written yesterday, and I gave you guys an advance copy. The theme of the article is you've got three cases out of the Supreme Court. They deal with rights. Two of them deal with rights that are actually enumerated in the Constitution, specifically in the First Amendment. One of them deals with a right that has been invented by the Supreme Court. The court treats the unenumerated right, the right it invented, with very great respect. It overturns two Texas laws that it deems too much infringe on the right, but then it fails to protect the two rights actually enumerated in the Constitution, and one of them, as you point out, is the free exercise of religion. This is a case called the Stormins case, and it arose in Washington State. Washington had a very liberal governor whose name was Christine Gregoire, and it wasn't enough for her to have legislation that made abortifacients, the morning after pill, generally available. She had to get a rule that said that even if you were, let's say, a conservative Christian and you personally objected to abortion, if you were a pharmacist under her proposed rule, you actually had to, your pharmacy had to dispense the drug. And what your religious beliefs were didn't matter. Now, the Supreme Court had earlier held that it violates the First Amendment for government officials to target particular religions or particular religious beliefs with legislation. But that's exactly what was going on in Washington State. The governor wrote a letter to the state pharmacy board asking that they change their rules so that conscientious dissenters could no longer refuse to dispense these drugs, and that she also announced that she could fire any member of the pharmacy board. Her allies on the State Human Rights Commission threatened the pharmacy board with personal liability if they didn't deny if they didn't deny an exemption to religious dissenters. And so the pharmacy board caved. The one pharmacy was then attacked by the state, and it defended itself. And the United States District Court, the trial court in Washington, in the state of Washington, decided that the pharmacy's religion rights had been violated. But when the case went up on appeal to the Ninth Circuit Court of Appeals, that decision was reversed. What was disturbing was that the U.S. Supreme Court didn't intervene. It allowed standing this targeted action by the state of Washington, this attack on certain conservative religious beliefs or on the beliefs, for example, of Catholics, allowed it to let stand in violation of one of its own most famous precedents. So it's a very disturbing decision, and as Justice Alito said in his dissent, it is alarming if that's how the Supreme Court is going to be treating freedom of religion in the future.
They were up against a break, so we're going to take a quick pause here. If you like to comment, give us a call, 721-1290. There are several decisions we're going to talk about from this as-yet-to-be-released article that we want to hear more about from Rob Natelson. We'll be right back with more in a moment. Thanks for joining us on Talkback. 721-1290 is our number, and Rob Natelson joins us on the telephone from the Independence Institute.
And you were just describing a competing rights, some which originate in the Constitution and some that were apparently drafted whole cloth in more recent times. Can you give us some names or terminology where you see what do you call these different rights?
Okay, well, the rights that are actually listed in the Constitution are called enumerated rights. That would include the right to free speech, the right to freedom of religion, the right to keep and bear arms, the right to be free of unreasonable searches and seizures, and so forth. The U.S. Supreme Court has, over the years, interpreted two clauses of the Constitution called the due process clauses as creating certain other rights that they deem to be important. Now, I will say that the due process language really does not have that meaning, but the Supreme Court has been doing this sort of thing for many years. And the most famous two examples today are the right to privacy and its derivative right to abortion. And so you've got a situation now where the Supreme Court is defending the abortion right much more vigorously than it's defending free speech or free press rights, which is obviously, I mean, even if there were an abortion right, the fact that it's not actually listed in the Constitution would suggest that maybe it's entitled to a little less respect, not more respect, than the rights that are listed in the Constitution. And that's why I said I think they've gone completely off the rails in this particular area.
All right, let's go ahead and take a quick phone call here from Catherine. Catherine, thanks for holding. You're on with Rob. Go ahead.
Good morning. Good morning, Rob.
Hi, Catherine. You got another one of those questions I can't answer.
Well, I don't know. We'll see. Richard Posner, who is a Seventh Circuit Court judge, wrote an article in Salon, I think it was last week, stating that the Constitution should not be studied. It's valueless or used for judicial decisions because it's outmoded 18th century thinking and has no value in the 21st century. So a couple of questions based on that. Is this a violation of his oath of office, and are there any consequences to that? And two, could this opinion, as it's stated in public, be used as a cause for any appeals on any of his decisions?
Well, it's a great question. I mean,
Thanks, Catherine.
Speaking of somebody who's gone off the rails, I think Judge Posner is a good example of that. He's a man of very great accomplishments. He largely created the modern law and economics movement, where economics is studied, where economic tools are used in the study of law, and he contributed a great deal. However, his underlying philosophy is that of utilitarianism. That is, greatest good for the greatest number, and he's not so much focused on individual rights or rules of law. He is, as you indicated, on the United States Court of Appeals for the Seventh Circuit, and he's taken a number of very controversial positions over the years. To focus in specifically on your question, Catherine, I haven't read the article, but if he starts applying his philosophy that we should ignore the Constitution, if he starts applying that in the actual decision of cases, yeah, I think that's a cause for impeachment, because the Constitution is the supreme law of the land, whether he would want it to be or not. If he's simply expressing his private opinion and not applying it in cases, well, he's free to express that under the First Amendment. But having done so, he runs the risk that people with cases arising under constitutional issues will demand that he recuse himself or disqualify himself because of his beliefs, so that he's going to have to face some choices as to whether he recuses himself. To finish up my answer, the remedy, if he starts disregarding the Constitution in his adjudication, as opposed to expressing his private opinion, the remedy is impeachment. But we know in the current political atmosphere that's highly unlikely.
Now, Rob, one thing that I think, again, I can't see into his mind, but what I think he may be thinking, if that's worth anything, is you might think, well, he doesn't want to have to depend on the opinions of people back in that time when it was a totally different time than it is now. And a lot of it simply might have to do with the increase in population. That back then there were relatively few people in America having individual rights. Yeah, but there was enough room to grow and stretch, and people could exercise their own rights. But now there are 360 million people in America, and we need to start putting our own individual freedoms aside and start thinking about the collective more. So could that be part of it?
Well, I think that the argument that the Constitution is outmoded often derives from misunderstanding of the Constitution. It tends to be expressed by people who don't really understand various aspects of the Constitution that are important. One aspect is the fact that the Constitution is amendable. We've amended it 27 times, and in many cases, those amendments have been adopted to respond to new conditions. In areas where the Constitution became outmoded, we've amended it, and that's fine. But the other thing is that very often people don't understand the terms of the Constitution. While they're not as infinitely elastic as some progressives would like, they tend to be in many respects flexible. A great example is the Fourth Amendment, which protects against unreasonable searches and seizures. Well, obviously, what's reasonable or not reasonable is going to depend upon, to a certain extent, upon social conditions and technology of the time. But I think a lot of the argument about the Constitution being outmoded doesn't arise from misunderstanding and doesn't arise from lack of appreciation for the amendment process. It simply arises from people who basically want to reestablish the British form of government that we rebelled against. Under the British form of government, the Queen in Parliament is the supreme law. Ultimately, the politicians can do whatever they want, and there are a lot of people in the American elite who would like to see that system adopted in the United States.
Okay, now, Rob,
and my response to that is, if you like that system so much, you might want to emigrate to Britain.
Yeah, we're going to take a quick break. We're kind of overdue, and we also have a news update we're going to share. So go ahead, John.
We had a question from a caller if there was evacuations near Lincoln. There were, apparently. There's been 4 cabins that burned down near Lincoln, near the Elk Trail Loop area. The fire still, as far as NC-Web is concerned, is just 10 acres there, and people are being allowed back to the area that had been burned.
Right.
But that's all we know.
Okay, so we'll be right back with more of Talk Back in a moment. Thanks for joining us on Talk Back this morning. Of course, a very special day, as it is every month, when we get to visit with Rob Natelson from the Independence Institute. In the 2 minutes we have left before our hard break, Rob, there are other things in your article that you really wanted to point out. Maybe we can just get some highlights, and then we can, perhaps get more extensive explanations in the next hour.
Sure. The theme of the article that I gave you guys an advance copy of, it's not been published yet, is that in the area of personal rights, at least, the Supreme Court seems to have really run off the rails. And I give as an example 3 cases decided in this past term. Two of them that deal with First Amendment rights, freedom of the press and freedom of religion, actually listed in the Constitution, which the court does not adequately defend. And then another so-called right, abortion, which is not in the Constitution, that it super defends. And so I'm hoping that when we come back, we can focus in a little bit on the freedom of the press case, because it has some disturbing implications for anybody who wants to participate in politics.
Well, I think it's interesting, too, this whole idea, we kind of touched upon religious liberty. There have already been many court decisions, for instance, during the same-sex marriage debate, when people said, well, I don't want to bake you a cake, or I don't want to DJ your wedding, or whatever, and then they were taken to court. So it seems an extension of that, doesn't it?
Yes. One of the points I made in my posting last year about the same-sex marriage case is that if you are religious, you need to be afraid, because the court, through Justice Kennedy, signaled rather strongly that while the court would respect your right to engage in abstract debates about what marriage was, it really was not going to respect your ability to act upon your beliefs. And the freedom of religion case is a great example. We've got pharmacists being targeted by the state of Washington and essentially being forced out of business if they oppose abortion.
Yeah, and with that, we have to take a quick break. We'll come right back after the top of the hour. A whole nother hour with Rob Natelson. So the lines are open. If you want to get in the queue, it's 721-1290. Stay with us. Welcome back, everyone. Hour number 2 of Talk Back, brought to you by AAA. Pays for itself with discounts on big brands. Join now, get a free canvas tote. Brought to you by Western Montana, New Holland, south of the Y on Highway 10 across from the Axeman. Spray Green Lawn, providing lawn aeration, fertilization, and weed control. Save 15% by calling 207-9273. At Office City, celebrating 100 years in business. See them for office supplies, furniture, price match guarantees, and free next-day delivery. Yeah, here we are. We're back on Talk Back this morning. John King's over there, and I'm Peter Christian. Rob Natelson joining us from the Independence Institute. All right. And we've got calls coming in, so we're going to get to those here in just a moment. But, Rob, I interrupted you right in the middle of a very important point because we had to take our break. So if you wouldn't mind just go ahead and fleshing out what you had said before.
Well, what we were talking about is this article I have that I gave you guys an advanced peek at. Using or referring to 3 separate cases that the Supreme Court decided just in the last few weeks, and illustrating the cases illustrate, in my words, that the Supreme Court has kind of run off the rails in the area of personal rights, that you've got enumerated rights actually listed in the Constitution, like the right of freedom of the press and freedom of religion, that the court is under-enforcing. They're not particularly protecting, but they are protecting and over-enforcing rights that are not in the Constitution, like abortion, that the court essentially created. And a great example, second example, I mentioned freedom of religion as one, but a case involving really freedom of the press. There was a family-oriented nonprofit in Delaware that put out a voter's guide every 2 years for the election. And the voter's guide chose issues that were important to religious conservatives, like same-sex marriage and health care and that sort of thing. And they asked people running for Congress and people running for state legislatures how they stood on these issues, and then they would indicate how each person, whether a candidate favored or opposed a particular stand. These voter guides are also common in Montana. They're common nationwide. Well, putting out a pamphlet like that is a classic example of freedom of the press. That's what the First Amendment freedom of the press clause was designed to protect. And part of freedom of the press, as the founders understood it, was the right to present your opinions to the general public anonymously, without being subjected to personal attacks or attacks on your family or attacks on your livelihood. Well, Delaware passed a piece of legislation which said that if you spend more than $500 putting out material related to an election, you have to disclose all of your donors who gave more than $100 or more. Now, this is not material having to do with a candidate's campaign. It's not material which says vote for or against a particular candidate. It's simply purely informative material for a particular kind of voter interested in a particular kind of issue. Now, under the circumstances, it really would have a chilling effect, I think, on the people's freedom if you've got to reveal the identity of everybody who gave $100 or more. And I can tell you some chilling examples of stories that illustrate that. So this is a good example where the U.S. Supreme Court could have taken a strong stand for First Amendment freedom and failed to do so. It allowed Delaware to carry out its intrusive scheme. Now, what's wrong with that? Well, what's wrong with that is that the history of these disclosure laws has demonstrated that as soon as the names of who contributed to this voter guide become publicly available, very zealous and rather unscrupulous left-wing hit groups start campaigns of harassment against these people. And so it forces people who want to contribute, with a $100 check to politics to simply withdraw. It's actually not a very good influence on the political system.
I know you can explain the other side's point of view oftentimes. As a former teacher, you probably had to do the devil's advocate thing a lot in class. So I was hoping maybe you could explain something to me, because it's my understanding that the case Griswold versus Connecticut opened up the door to what they call the right of privacy, or the right to privacy, which was basically the framework for where you get abortion in the United States, at least through Roe v. Wade, and was used in this recent case, as my understanding, that you had mentioned first, the first case. Why does this right to privacy not go on to other things, like the right to privacy when you come to who you support or ideas that you establish?
Right. That's a very good question, especially since, as I demonstrated in an article that was published by one of the NYU journals last year, in particular, the right to author privacy is critically important to freedom of the press, and freedom of the press would cover not just the newspapers, it would cover the rights of people who publish op-eds in the newspaper or letters to the editor or who publish pamphlets or who publish political advertisements. The right to privacy has always been manipulated by the court to protect those aspects of privacy it likes and not to protect those aspects it doesn't like.
30 seconds.
So it's a great example. They don't protect the right of people to write anonymously for the newspapers, but they do protect the right of people to get abortions. It depends upon more what the particular judge's personal priorities are. Griswold versus Connecticut, the case you mentioned, was decided, I think, in 1965, I think it was.
Yeah.
And but it was actually based upon even earlier cases that go back to early years of the 20th century, where the court started using the Due Process Clause of the Fifth and 14th Amendments to impose their particular political agendas on the Constitution. It's a rather pernicious thing, but it's been going on for a very long time.
Okay, we're going to take a quick break, and Buck is waiting very patiently to visit with you, Rob. We also have two other lines open. 721-1290 is our number. Rob Natelson from the Independence Institute's with us once a month, and so we like to get as much as we can from that visit, so that's why we open up the phones and let you ask your questions. We'll be right back. Okay. Too bad we don't have cameras in here. 721-1290 is our number. 1-800. Yes, we do make fun of the commercials around here. I'm sorry. Let's get Buck on the line. Buck, good morning. You are on with Rob Natelson. What's on your mind, sir?
Well, good morning, and thanks for continuing to make yourself available to us, Rob.
You're very welcome.
Everything
Buck.
Excuse me.
Go ahead.
Everything has an exception. I suppose the original Constitution had to somewhat accommodate slavery because there wouldn't have been a union otherwise. But as a layman, it's my impression that the Constitution and the original Bill of Rights are almost sacrosanct because unlike Justice Posner's view, they really dealt with the peccadillos and felonies of human nature, and they will be timeless unless and until we maybe, start genetically engineering ourselves. The same cannot be said of some of the more recent additions to the Constitution. Would you just comment on that viewpoint, please?
Well, yeah. One of the great strengths of the Constitution, and the reason why so much of it has lasted for so long, is precisely what you identify. It is crafted to deal with realities in human nature. I mean, a great example is the series of checks and balances, the checks and balances between the legislative, executive, and judicial branches on the one side and between the federal government and the states on the other. The idea is for ambition to check ambition, abuses to check abuses. It takes a somewhat grim but I think accurate view of human nature. I think some of the criticism of the Constitution, which is based on the idea that the politicians should be able to do whatever they want to, except in very small areas, that's based upon an inaccurate impression of human nature. It's also true, as you said, Buck, that the people who drafted the Constitution had to make some nasty compromises, and slavery was a good example of that. But that's long gone, isn't it? I mean, we got rid of slavery in 1865 with the 13th Amendment. That's what the amendment process is for.
By the way, Peter has been talking all morning about this press conference with James Comey.
Right.
And I do have a tweet from someone that's watching it.
Go for it.
They say, FBI chief says no evidence classified information was intentionally mishandled, but Hillary Clinton's staff was careless at times. She says, it says breaking, FBI
now,
chief.
You have to tell me. We had a discussion about this off the air, and isn't that almost exactly the formulation I suggested?
Yep.
I said that there may have been errors in judgment, but nothing indictable.
Yep.
FBI chief also says Hillary Clinton used multiple servers during her time in office. And that's it for the new stuff. Maybe we'll find out more.
Okay.
And so I'm sure that at this point, at this moment, Hillary Clinton is addressing the National Education Association saying, you see, nothing, they've got to move on now, nothing to see here, what difference does it make?
I'll use this as a CEC moment.
Okay.
I think I've mentioned on this program that the international rating agencies, that they rate countries on the level of freedom and other factors, that one of the important factors for any free society is the rule of law. And the United States rating among nations on rule of law indices has tumbled in recent years. We used to be very highly rated in the rule of law, and increasingly we see that the rule of law in this country being threatened. Well, here's a great example.
Yeah, it's
new information. Breaking. The FBI recommends no charges in connection with Hillary Clinton's use of private servers. The FBI chief won't take questions from the press.
Surprise, surprise. Wow. Okay, so there you go. Now the path is clear. No indictments. Nobody's. So I just won that
looks
dollar
like you get
bill
a dollar
up there.
from Walt.
I get a dollar from Walt Kiro. So there you go.
You mean Walt Carroll actually bet that there was going to be a criminal charges recommended?
Yes, he did.
I see. Well, I think the tip-off was when Loretta Lynch announced that she would abide by whatever the Justice Department came up with.
After a nice, friendly chat with the former President Bill Clinton in her private plane alone with no reporters present.
Right.
You see.
Right.
Which is a dangerous place for any woman.
Where they talked about grandchildren and golf, if I don't miss my guess. Anyway. The whole rotten mess just stinks to high heaven, in my opinion. So there you go. But that's just me. What do I know? I'm just a dumb disc jockey from Missoula, Montana. What do I know? So anyway, moving right along. Now, there's another thing in your article that we haven't even had a chance to talk about that yet.
This is the big Texas case, right?
Yeah, the case in Texas, which you also address.
Yeah, this is the women's whole health case. I mentioned earlier the theme of the article is that the Supreme Court has gone off the rails in the area of individual rights, because while they're under-protecting the rights actually listed in the Constitution, when it comes to rights that they create themselves, they're over-enforcing them. And one example of that is abortion. And the women's whole health case, which just came down, is a good example of this. Texas passed 2 laws that the court upended, okay? One of the laws said that abortion facilities have to comply with the same restrictions that are applied to other ambulatory surgical centers. Now, I think most people would say that abortion is a surgical procedure. They might argue as to whether it's a serious or not a serious procedure, but I think it's a surgical procedure. And so it would seem reasonable for a state to say that if you're performing abortions, you should comply with the rules that other surgical facilities have to comply with.
Can I step in for just a second here? From my personal knowledge, my wife is an RN. She works at a place called the Birth Center. And they have to have a contract with the local hospital in case there's an emergency situation during a birth, so that they can go and that the baby could be taken care of if there's needs that can't be met at the birth center.
Well, that actually ties into the second Texas law that the court overturned, which said that if a doctor performs abortions, he or she has to have admitting privileges at some hospital within a 30-mile radius. What that means is that if there are complications, the doctor has to be very in a position to very quickly admit the patient to the hospital. Well, both of these restrictions got overturned, and it got overturned because the court applied a heightened version of a standard that 3 judges had advocated back in 1992 called the undue burden standard. And basically what the standard says is if the law decreases significantly the number of abortions, then the law is unconstitutional.
Yeah, we have one minute. So.
Yeah. And so you think of all the regulations that are adopted on economic activity, which not only decrease the availability of a service, but actually put people out of business. The game farm regulation in Montana is a great example. They are regularly upheld by the courts, but if the subject matter is abortion, then suddenly all the rules change, and even a fairly modest regulation is overturned because of the strength of the abortion right in the court's eyes.
Just real quick, but I wanted to give credit. The tweets that I'm reading are from Paula Reed. She's a reporter for CBS.
Okay.
And she has this final one, or the most recent one. She says, I was the only reporter to shout questions at the FBI chief. I asked if this pronouncement comes so that Hillary Clinton can campaign with President Obama today, but there was no response.
The headline here says FBI director, quote, Clinton and aides, quote, extremely careless, end quote, in email handling of classified information.
Yeah.
So there you go. We'll let you chew on that for a minute. We'll be right back. Hey, we're back on Talkback. 721-1290 is the number. 3 lines open. We're talking with Rob Natelson from the Independence Institute. And boom, magic, she's cleared. Big smiles all around. Nothing to see here. Let's move on. So anyway, that's that's what's going on in Washington, D.C. right now with FBI Director James Comey. Yeah, they kind of made some boo-boos, made a couple little slips and errors, but it's okay. You know, it's no problem. Let's move on. So anyway, Rob Natelson from the Independence Institute, where we're continuing what I think is a much more substantive discussion here of what's happening with the Constitution, especially with the recent Supreme Court rulings that just came down in the last few weeks.
Yeah, we were talking about the fact that the Supreme Court issued 3 opinions dealing with individual rights, and the court is not protecting freedom of religion or freedom of the press that much, but it is protecting a right it created, the right of abortion. And the dramatic difference between, abortion is an economic activity. People pay for abortion in the same way they pay for food or they pay for clothes. And yet if you compare the level of regulation that the courts allow on almost every other aspect of the economy compared with the amount of regulation that they allow with respect to abortion, the difference is absolutely dramatic. Some of you may remember a few years ago, voters in Montana passed an initiative that essentially put Montana game farms out of business. Previous to that, game farms had been regulated by the state. They were for profit, so they paid taxes and so forth. An initiative was passed that established regulations that essentially banned the game farms, and people went bankrupt. They had to close entirely. Those regulations were upheld by the courts. But on the other hand, when the subject being regulated is abortion, if the regulation could even reduce the number of abortions somewhat, then somehow the regulation is unconstitutional. It's a very strange way of adjudicating.
Have you actually read the decision for the Whole Women's Health?
Oh, yeah.
So are they using the right of privacy still?
Oh, yes. Their argument is that the Fifth and 14th Amendments say that in the case of the Fifth Amendment, it says the federal government won't deny anyone life, liberty, or property without due process of law. The 14th Amendment says no state shall deny any person life, liberty, or property without due process of law. What these terms mean, essentially, is that if the state is suing you, they can't change the rules as they go along. That's what it's supposed to mean. But for about 100 years now, the Supreme Court has seized upon that language to protect rights that whatever justices happen to be sitting on the court at the time deemed to be important, and they use that to strike down state and federal laws that they think unfairly or improperly interfere with those rights. And one of those is the right to privacy, of which the right to abortion is considered a branch.
Go ahead.
Go ahead. I was just going to ask you, Rob. Do you have an inside track, or perhaps since you're much closer to the Supreme Court than most of us are, as to once the presidential election has come and gone, if there are any justices that are anticipated to retire within the next year, that the new president can jump on and say, "Here we go. Let's get the court the way we want it."
I don't follow the Supreme Court that closely because a lot of my work is historical. I'm best known for my work in the original Constitution.
Sure.
And so I don't do a lot of 18th century research. Obviously, I have to keep up with the modern stuff now, but I'm not a Supreme Court watcher. With that caveat, I'll say it's widely believed that Justice Ginsburg is interested in retiring. She's not well, and she's getting up there. And so the next president may have an opportunity to replace her.
I wanted to talk to you a little bit about the idea that the court's decisions today may come back to hurt them in the future. Do you think that the way that the court is treating, the way that it interprets things and puts the power in the lineup of justices now could come back around to impact things in the United States later?
This is a really great question because there's a very disturbing trend that many people in the bar, in the legal profession, consider very disturbing, and that is the treating of judges as mere politicians. So they would object to judges having to campaign for office. They would object to judges being able to make statements about how they might handle cases in the future and so forth. And I think that's true. I think there's a general politicization of judges, but it's largely a self-inflicted wound. What has been happening is that while judges have always been political to a certain extent, it has really gotten over the top in the past few decades. And so this has fueled a very widespread cynicism among the American public about judging, a belief that, because some cases seem to be politically driven, that therefore all the cases are politically driven. And that cynicism, while it's overblown to a certain extent, has some factual basis. So the judges, judges sometimes complain about being treated as if their decision making is merely political. But as I said, that's largely a self-inflicted wound. The further they get away from the text of the Constitution, to greater extent that they continue to make up rights like the right of same-sex marriage or the right of abortion, more and more they're going to be seen as political actors, and more the courts fall in public esteem. So it's a serious problem, and American people are going to have to address it. I think ultimately, Peter and John, the public is just going to have enough. They're just going to that the repute of the courts is going to fall so low that the American people are going to demand constitutional reform on the state level and on the federal level.
Yeah, it seems like they've stopped calling balls and strikes and started calling humphalumps and woozles and whatever they want to imagine.
It's really common for people to talk about dictators and black robes and so forth. That was not common in my youth. That kind of rhetoric, and I shrink from that kind of rhetoric. But I have to say, when I see a collection of cases like the three that I discuss in my article, I say, what the heck is going on here?
We're up against a break. So.
When we get back from the break, I want to ask you where you think this started. You say it didn't happen in your youth. Was there a moment, and it's a self-inflicted wound, so what was the dagger that inflicted this wound? Was it a particular Supreme Court decision?
The first cut is the deepest. We're going to come right back with more in a moment. This is Talk Back, and of course, our special guest, as always, once a month, we visit with Rob Natelson from the Independence Institute. Now, Rob, John just asked an interesting question.
Yeah, I didn't know the conversation would go this way, but I started listening to this new podcast called More Perfect. It's by a bunch of liberals that work for NPR. They do another one called Radio Lab. It's a pretty fun show. But More Perfect is all about the Supreme Court, and they asked the question on this podcast, what is the start of politics in the Supreme Court? When did we really get politicized? And their answer and was another Warren Court decision. So anyway, I wanted to ask you, Rob, what your thought was. If you were asked that question, when did the court become politicized? When would you have answered?
Well, Baker versus Carr simply held that the apportionment of state legislatures could be a judicial question. That is to say, if a legislature got too far out of whack from population, that the court could consider a complaint under the Equal Protection Clause of the 14th Amendment. That certainly was an intervention by the court in an area where it had not been willing to go before, but it's certainly not a turning point. There's always been a certain amount of politics in the court. After all, courts consist of humans, and humans are political. But by and large, there has been a great slippage from the founders' ideal. The founders' ideal was really the British court system, which at their time was pretty neutral and pretty professional. As to where things began to get out of hand, well, I think it's been a slippage throughout the 20th century. Let's just put it like that. I think beginning in the early 20th century, the court started misusing the due process clauses of the 5th and 14th Amendment to strike down laws that they didn't like. It accelerated during the New Deal when the courts started applying political tests to the line between federal and state powers. It got much worse during the years of the Warren Court and the Warren-Burger Court, where the court started becoming much more aggressive and activist. During the Rehnquist years, it abated a little bit. We're talking about the Supreme Court now. It abated a little bit during the Rehnquist years, but it seems to be accelerating again to the point where wide swaths of the Constitution no longer seem to apply. I think much of the Constitution is still in effect, but large parts of it don't seem to apply anymore. At the state level, it depends entirely upon the state. Certainly here in Colorado, there have been political influences on the Colorado Supreme Court, as any lawyer can tell you, but the situation in Montana has been much, much worse, with the court very highly political for very many years.
Okay, let's get back to the phone. Marilyn is up first. Marilyn, you're on with Rob. Go ahead.
Okay, yeah, it is very disturbing what we've been seeing for a long time. They are totally wiping out the Constitution, nullifying it. For those people that are worried about the Convention of States, Article 5, and, they say that, it'll wipe out, it'll nullify the Constitution. Well, no, the government's already doing that. The Supreme Court's already doing that. And this Texas thing, I hope there's some cases being filed for states' rights, if we still have any left. And right to life, is obvious. And property rights. I heard a new thing, on the transgender bathroom thing. This is a property rights issue that we have had property rights being taken away from us, and that's still happening. So this is a big, huge problem, and we need to do the Convention of the States. I know you'll agree with that, Rob.
Okay. Thanks, Marilyn. So what do you think, Rob?
Well, of course, as most listeners know, I certainly agree with Marilyn on that point. The difference, one of the differences between the Convention of States and the Supreme Court is that the Convention of States can't actually put anything into law. Anything it proposes is only a proposal, and it still has to be approved by 3/4 of the states. Where when the Supreme Court comes up with one of its rogue decisions, that then becomes, at least in most people's eyes, the law of the land. And so we have in the past had constitutional amendments that have overturned the Supreme Court. Interestingly enough, the Supreme Court does tend to take that chastening seriously. It tends to respect those constitutional amendments. But if you don't check them in the areas where they're going overboard, then they will continue to go overboard. That's the lesson of history.
Okay, we're going to take a quick break here. Emmett is waiting very patiently. We'll get you on. Plus, John is answering the phone. We also have Frank, who wants to visit with you, Rob, and one line open at 721-1290. It's our once-a-month visit with Rob Natelson from the Independence Institute. We'll be right back. Talkback rolls right along. I'm Peter Christian, and of course John King, our show producer, and Rob Natelson joining us from the Independence Institute. So lots of folks want to visit with you on the phone, Rob, so let's get right to it.
Sure.
I believe this is Emmett. Emmett, good morning. You're on with Rob Natelson. Go ahead.
Oh, thanks for taking my call. Yeah, I just got in around 10 minutes ago. You probably have already covered this and talked about this. I'm sorry if I missed a lot of it, but I do have a question about, the Texas cases striking down their, abortion laws about sanitary baby-killing facilities. I know that's an oxymoron, but I'm confused how that could be an undue restriction on, quote-unquote, a woman's right to a safe and legal abortion. How is it safe if it's an unsanitary facility? I mean, we insist that now care clinics and hospitals are spick and span and immaculate. If you go, if I go into now care with bronchitis or something, or a strep infection or something, that place is always spick and span and immaculate. I certainly wouldn't want a dirty place. So all they have to do is get it up to code. The abortion clinics, all they have to do is make it spick and span, and it won't close any facilities. So I'm kind of confused as to the court's convoluted idea that a unclean environment violates women's... this mental gymnastics is insane, but that's the left. But you probably have already talked about this. I just kind of like to hear it again or something.
All right, let's let him answer that. Thanks for the call, Emmett. Go ahead, Rob.
Well, yeah, thanks for the call, Emmett. First, you did identify one little irony here. Normally, if a regulation is passed and providers go out of business, in other words, if you impose a regulation on grocery stores and small grocery stores go out of business, then the bureaucracy touts that as a triumph. They'll say, well, we got rid of marginal or fly-by-night or unsanitary operators. In the area of abortion regulation, it works just the opposite. If a regulation causes an abortion facilities to close, then that's viewed as a bad thing. So the U.S. Supreme Court relied upon information that had been presented by the court, which suggested that if these two regulations were allowed to take effect, that they would, or I think in one case had already taken effect, that they would close abortion facilities, and that would make it tougher for women, especially in rural areas, to get abortions. That the standard that the court uses, if it can be called that, is an undue burden standard. That is to say, if it makes it significantly tougher for a woman to get an abortion, then it's unconstitutional. Now, in fairness, I will say that neither of these regulations had to do with dirty or unsanitary facilities. That was not the issue. One of the regulations required physicians who performed abortions to have admitting privileges in hospitals within 30 miles. Okay, and the purpose of that was to facilitate admission to a hospital in case complications developed. The other standard required abortion facilities to meet the same regulations that applied to other ambulatory surgery centers. And the court said, well, some of those regulations that apply to other surgery centers don't really apply to abortion facilities and therefore represent an undue burden. Again, the problem with that is that any broad category of regulations always apply more to some providers than to others. And the courts don't bother themselves with those discrepancies in other cases. It's only in the case of abortion, which sort of gets super protection above virtually every other economic activity or healthcare activity that people engage in.
Well, I'm sure the court will start using the same approach towards the coal industry as well.
Yeah, right.
Protecting it from undue regulations.
The coal regulations, for example, can simply close down coal mines. Well, under the court's economic regulation jurisprudence, so that's too bad. That's just tough. That's a matter for decision to be made in the democratic process, unless it has to do with abortion. If it has to do with abortion or contraception, then we don't allow the democratic process to operate.
All right, let's continue on. Frank, you're on Talk Back with Rob Natelson. Hi.
What is the definition of an ex parte conversation, and who decides when it has happened?
Okay, thanks, Frank. So what is ex parte, Rob?
Ex parte, I'm not exactly sure the context in which the question is being asked, but ex parte is a Latin word. It means coming out of one party as opposed to agreed upon by both parties or with notice to both parties. And ex parte usually refers to a party's right in some circumstances to request relief from a court, usually temporary relief, without notifying the other side. Obviously, this is not something that is generally used, but it's permitted in some circumstances. For example, a woman who is being abused by a spouse or by another person might be afraid of her life if she notifies her husband and then they wait for a court hearing. So she may go to a court and get an ex parte restraining order that protects her from abuse, and that's done very quickly without notice to the husband. Eventually, the husband's given notice, and he's got a right to defend himself. Often in ex parte cases, the party getting the order has to meet a very high burden of proof and may have to post a bond in case there's any other damage to the other party. So that's how the term ex parte is used in law.
Okay, we're going to come right back. Gene, Alan, and Mike, and we're at our final break. This is 1 minute, and we'll be right back. And all the lines are full, so we'll be right back. And we're back on Talkback. 721-1290 is the number. Rob Natelson joining us from the Independence Institute, and everybody wants to talk to Rob, so let's get as many calls in as we can. Quickly, Gene, what is on your mind, sir?
Well, I'd like to come back to the most recent abortion decision, and then relate it to gun rights. Okay. I agree that abortion should not be a constitutional right, but the fact is, today it is. And the Supreme Court, in the majority decision, citing undue burden, was saying that there was no reason for the regulations that Texas was trying to put on abortion clinics and doctors, because in the past, abortion has shown to be so safe. And I mention this because what I'm wondering is, if there was no undue burden in this Texas case, then what if a state wants to severely limit constitutional rights when it comes to guns and puts all kinds of regulations, seeming to me that there is much more reasonableness in this area, where you have, children that are dying and guns being misused.
What you're saying is guns are fundamentally unsafe, is what you're saying, right?
Well, people use them in unsafe ways.
Right.
Yes.
Okay. All right. Okay.
So why couldn't a state say that and take away, in effect, the constitutional right?
Okay, let's get to answer that. Thanks for the call.
Well, it's a great question, and it circles back exactly to where we started. Remember, we started with this article that I had given you guys an advanced glimpse of, which cites three different cases from the U.S. Supreme Court just decided, two of them in which the court did not adequately enforce rights enumerated in the Constitution, but another one where they super-enforced a right that they themselves had created. Now, the two rights that they under-enforced were freedom of the press and freedom of religion, but you could say exactly the same thing about the Second Amendment. The court, back in 2008, did hold that the Second Amendment is an individual right. Nevertheless, the court has not given the Second Amendment the kind of protection that it has given abortion rights, for example. The court's review and the scrutiny with which they look at abortion regulations is far greater than the scrutiny with which they view regulations of Second Amendment rights. My suggestion is it should be exactly the opposite. Second Amendment rights are specifically protected in the Constitution, and abortion is not.
Okay, let's get Alan on the line. Alan, you're on with Rob. Go ahead.
Yeah, good morning, Rob.
Good morning, Alan.
The Constitution created a system of check and balances, and if Congress had not given away their power, what could they have done to block some of these things that the Supreme Court is doing?
What could Congress do to block them?
Yes.
Well, one thing is some of these Supreme Court decisions relate to federal programs, and so the Congress can certainly defund federal programs where it does not like the way that the Supreme Court has interpreted the language creating or governing those programs. Secondly, the Congress can propose constitutional amendments to overturn Supreme Court decisions. The Congress did that with the 11th Amendment, with the first sentence of the 14th Amendment, and with the 26th Amendment. In each case, they proposed amendments that overturned Supreme Court decisions. The Congress also, specifically the Senate, can ride herd more carefully on who gets approved for the U.S. Supreme Court, because the Senate has to approve presidential nominations. The Congress can begin impeachment proceedings against sitting judges who disregard the Constitution. The House of Representatives can impeach them, and the Senate can convict them.
Do we have anybody that you think qualifies to be impeached on the Supreme Court right now?
I'm not going to specifically get into that, other than to say that I think that there are areas of the Constitution or areas of the law now where the courts are plainly disregarding the Constitution, and they have an oath to uphold the Constitution. But I'm not going to get into to naming names at this point, for the simple reason that will be seized upon by people as evidencing the claim that my commentary is purely political, and it's not.
Okay, let's get Mike. We have 2 minutes, Mike, quickly.
And by the way, before Mike speaks, let me just mention, I happen to agree with the concept of a right to privacy. I think a right to privacy is a great thing. I just don't think it's part of the U.S. Constitution, and that's the difference. There's a difference between what you personally would like and what's in the Constitution. Go ahead, Mike. Sorry.
Go ahead, Mike.
Oh, sorry about that. It's such a serious conversation. I feel kind of bad about asking this question about options for people about the transgender and bathroom situation. If I was a millionaire or a man of disposable income, could I hire lots and lots of bikers, put them in a wig and lipstick, and put a sign around their neck saying, "I feel like a lady today," and have them just hover in bathrooms in like stadiums or at sporting events as kind of a sign of a protest, saying, tongue-in-cheek, it's going to be scary for women walking into a bathroom and seeing a biker in a situation like that.
With a sign that says, "I feel pretty, oh so pretty."
There you go.
All right.
Yeah.
Thanks, Alan.
Yeah, well,
Appreciate the call.
It's a great example. The federal government has taken the language of the 1964 Civil Rights Act and simply changed its meaning.
30 seconds.
Or changed the word sex from being the birth sex to something that the Obama administration prefers. And so, yeah, I'm actually surprised that some people haven't already begun a publicity stunt like that. But by and large, conservatives tend to be well-behaved, maybe too well-behaved. And we tend not to react the way our more effective leftist counterparts react to things that we don't care for.
Rob, we are completely out of time. Thank you so much. It's always such a pleasure, and we look forward to having you on again.
It's great, and thanks for having me.
Take care. All right, we're going to come right back. Have a great day, everybody.